side of things a few years ago when a local girl was murdered in Deeside. The family knew I had a legal background, so they asked me to try and change the law in some sort of way. So I'm basically the architect of what's now known as Jade's Law, which automatically strips parental responsibility from a murderer in such instances. And as a consequence of that, I've been asked further by other families across the country from time to time to help them with their particular campaigns. And this one, Danielle's family asked me a couple of months ago if I could help them with their particular campaign, which I'm going to focus on today. And this is probably one of the most difficult ones I've had to address, really, because it conflicts with two different aspects of humanity, really. You've got the human rights issues, where you've got freedom to do as you please in certain aspects, and then you've got certain responsibilities which you should bestow upon society as a way of life, really, respect. So I want to explore the challenge on the ethical dilemma which I have faced in this particular, and the dilemma sits at the crossroads of compassion, legal tradition, and societal responsibility. Now, this dilemma is embedded in what will be known as Danielle's Law. Yes.
There we go.
When I was first asked to consider supporting Danielle's Law, I wrote an article on LinkedIn in February, and I found myself confronted with one of the most challenging ethical dilemmas of my overall view on human rights. Because this proposal does something profound. It asks us to create a legal duty to assist individuals in immediate danger, and a duty that resonates deeply with our instinct to protect life, yet directly challenges a long-standing principle in British criminal law. And this tension is not abstract, it is personal, philosophical, and profoundly uncomfortable. Now, Danielle Haggerty, she was only 33 years old when she died in March of 2023. And in fact, tomorrow would have been her 37th birthday. She died following an act of self-harm during a violent domestic incident. And she was found unconscious and not breathing after a neighbour hearing a disturbance called emergency services. Paramedics restarted her heart. A CT scan revealed irreversible brain damage. She remained on life support for 3 days before being pronounced dead. Now, the coroner concluded that her death was, and I quote, the unintended outcome of an act of self-harm at the time of distress in the context of a volatile and abusive relationship and in the immediate aftermath of a violent argument. Witnesses reported that she had been locked inside the flat. She pleaded through the letterbox to be let out. She expressed suicidal thoughts. And after all this, her partner at the time continued to threaten her, argued with her, and then left. Following her death, he was arrested, but no charges were brought. I've since spoken with the family after reading the coroner's report, and there are certain issues which I would prompted the family to challenge the decision, but that's going to come in the future. Anyway, the family's appeal at the time was rejected. So now it comes to this particular campaign. Her brother, RAF Sergeant Jonathan Haggerty, launched the campaign for Danielle's Law, calling for a criminal offence to abandon somebody in immediate danger without seeking help. Her death highlights the devastating impact of domestic abuse and the urgent need for legal measures to protect vulnerable individuals. So it brings us to the core legal tension. British criminal law is anchored in a distinctive principle, and that is that there is no general legal duty to assist. The law punishes harmful actions, not moral failures. And as I wrote again in the article, which I have got published on my website, I'll give you details later on to read the full thing later. I wrote, failing to act even when morally indefensible is generally not criminal unless a specific legal duty already exists. And we come back to the previous speaker. Unless there's a corporate duty or a parent-child relationship, a contractual obligation, or a particular statutory duty, outside these categories, a person may witness violence, injury, or even life-threatening emergencies and face no legal consequences. Danielle's Law directly confronts this tradition. So what does it propose? Danielle's Law seeks to introduce a legal duty to assist someone in immediate danger, and it would make it an offence to knowingly abandon a person who is unconscious or gravely injured, fail to call emergency services when someone is in clear peril, or deliberately withhold assistance following violence or harm. Again, I refer to my article. This would create a new generalised duty in UK law, a requirement to take reasonable steps to preserve life. And this is particularly relevant in domestic abuse because there's masses of evidence to suggest that perpetrators often delay seeking help in order to avoid detection. Unfortunately, these delays can often be fatal. This proposal challenges the foundations of British criminal law. It's a form of negative liberty to positive responsibility. British law protects freedom from state coercion, and Danielle's Law introduces a duty to act. You may be criminally liable not only for what you do, but for what you fail to do. This is a profound philosophical shift. Creating a new statutory duty fundamentally alters the boundaries of criminal omission, and my article is clear that this shift raises legitimate concerns. Your own autonomy and the right not to act. The state should not criminalise moral failings. Compelling action risks undermining personal freedoms. It risks the over-criminalisation, because in real life, people freeze, people panic, people misjudge danger, and the law must not punish human fallibility. A legal duty shifts responsibility from institutions to individuals, and this creates what I think is a slippery slope. And important questions should be asked. Could the duties expand over time? And could a call for help, for instance, become you must intervene physically? Could immediate danger become reasonable suspicion? Could the duty expand from domestic abuse to all private conflict? Could mandatory reporting become criminally enforced? Could civil liability follow? These examples are not predictions, they are illustrations of why careful drafting matters. The duty to act is a profound shift in the relationship between the individual and the state. If we introduce this particular law, we must do so with absolute clarity about what it does and what it must never become. Now we have international precedent in this particular field. Countries like France, Germany and Belgium, the Netherlands and Switzerland all have an imposition to a duty to assist. I've got case law again online, which deals with particular cases from France and Germany in particular. France, for instance, in 1997, after the death of Princess Diana, the paparazzi at the time were held ultimately liable because they should have, rather than taking their snaps and giving chase, they should have really assisted with the injuries that occurred after the crash. A case in Germany where a senior citizen was at an ATM in Berlin. He had a heart attack. 3 people walked past him, and they were ultimately arrested and charged with failing to assist. Fortunately, he did live because a 4th person did come along. But I've got case law on that, other cases. Despite the risks, Daniel's law is not about policing morality, it's about preventing avoidable deaths. The safeguards, I think that there should be no obligation to intervene physically, because you obviously don't want to be putting yourself at risk. No liability if someone reasonably feels unsafe, and no punishment for honest mistakes. You should focus on deliberately knowing and abandonment. And as I said, this mainly falls within the category of domestic violence, where they may not have may not have had direct causation to the death, but they would have known that particular person's mental health, mental state at the time. In Daniel's case, I identified that proximity may well be established with Daniel's boyfriend at the time, because he had been with her for 6 years and would have known her mental state. That's my conclusion on that, isn't it? The law will target willful neglect and not human imperfection, and this distinction is crucial. At its heart, Daniel's law forces us to confront a simple but profound question. When someone's life is in immediate danger, should the law allow us to walk away? Or do we accept that, in rare and clearly defined circumstances, the protection of life outweighs the right to choose inaction? This is the ethical crossroads. Daniel's law would mark a profound shift in British criminal law. It challenges the principle that has shaped our legal identity for centuries, but it also reflects a modern understanding of vulnerability, domestic abuse and social and societal values. And as I concluded in the article, only by confronting these tensions openly can we hope to craft a law that protects the vulnerable without compromising the freedoms that define us. And that is the task before us. We cannot change what happened to Danielle, but we can change what happens next. If we believe every life has value, if we believe abandonment in moments of crisis is unacceptable, if we believe society has a responsibility to its most vulnerable, then we must be willing to have this conversation honestly, courageously, and with compassion. So that's the end of the presentation, but if you I've got something.